Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, fellas, it is really hard to believe that we're sitting here at December 20th. I'm still amazed that we're at the end of the year. Maybe as we age, our years go faster and faster because I don't know about you, but I can't believe that we've gone through another year.
Speaking as I think I'm the oldest, thanks.
What we thought we would do is a year in review to talk about the legislative and regulatory developments on restrictive covenants. And Russell's going to lead that part of our discussion. And then John's going to lead us through some of the trade secrets developments. We were emailing earlier today about the Appian versus Pegasystems case, the $2 billion trade secrets verdict in Virginia. And there just seemed to be a lot of activity this year, both on the restrictive covenant side, mainly on the legislative regulatory front, and on the trade secret side with some large verdicts and other significant developments. So Russell, you want to kick us off talking about what's going on in the restrictive covenant world?
Absolutely. So I'll start with the no poach side, and then I'm going to turn to the non-compete side. The no poach side is important because it's getting a lot of attention, and it has really. When you go all the way back to 2009, you may remember the tech cases where a number of companies had these agreements that they weren't going to solicit from each other. And the DOJ brought an action against them. It was a civil action back at that time frame, and they resolved it and everything was over. But then in 2016, again, just setting the stage for this. So in 2016, the DOJ and the FTC released what they call guidance for the HR executive, I think was the name. And in that document, they talked about how companies could not enter into so-called naked no poach agreements. So agreements from one company to another that they're not going to solicit each other's employees or not going to hire each other's employees. And that was kind of the lay of the land. We had that for a while. And then we started seeing the DOJ kind of going after some companies, especially they got a push from the Biden administration back in 2020 before President Biden was inaugurated. And then again on July 9, 2021, when President Biden issued his executive order. And in both of those, he made it clear that he wanted to do away with no poach agreements. So since then, we've seen several criminal cases brought by the DOJ, or at least participated in. Well, I guess brought by the DOJ. And then the DOJ got involved in some other cases as well. None of them have resulted in a conviction. So this year, there was earlier in the year, an acquittal in a case that the DOJ had brought against a company called DaVita. And then later in October of this year, the company called VDA OC LLC. It's a Nevada company. They're in healthcare staffing, and they pled guilty to conspiracy with a competitor to allocate employee nurses to fix the wages of those nurses. And that made the press because obviously the DOJ, put a lot out on that. So you're going to continue to see more of those kinds of cases. The DOJ is really coming down very hard on no poach agreements. The FTC is as well. And the FTC is continuing to look at both, and this will take us into the non-compete side of it. The FTC is continuing to look at both no poach agreements and non-compete agreements. And we've seen the FTC take action in connection with non-compete agreements entered into in the context of an M&A deal. So after the M&A is agreed upon, the merger is agreed upon, and then it goes for review by the FTC, and the FTC says, you got to get rid of these non-competes. You got too many people bound by non-competes. And so they're making a condition that the non-competes go away.
So, Russell, I think the most relevant question to our audience on this issue is probably the one that comes up all the time, right? Which is you're settling a restrictive covenant dispute, and one side or the other proposes, well, as part of the settlement, we should agree not to hire each other as employees or recruit each other as employees for some period of time. My understanding, and again, I'm not an antitrust lawyer, and I always get antitrust lawyers involved on this issue, but is that if it's in bona fide settlement of litigation, that can be a factor that would be considered, that it's not anti-competitive, it's not a violation of the Sherman Antitrust Act. What is your view on that? And, the question I get asked often is, we got to make sure we keep our executives out of jail. This is not a question of, is this going to be held enforceable or not? This is, can someone go to jail over this settlement agreement?
So I have heard, I like you, I am not an antitrust lawyer. So with that caveat, I have gotten different advice from different antitrust lawyers. And I have heard that in the context of a bona fide settlement of a dispute, that should be fine. I have also heard that even in that context, that doesn't alleviate you from the scope of antitrust laws, and the resolution still needs to pass muster under antitrust laws. And so the general advice that I have been given is, keep it as narrow as possible, keep it as tied to some underlying agreement that existed beforehand. I generally will take the view that it should be avoided if at all possible. Any sort of an agreement like that should be avoided if there's any way to avoid it. And it also, you've got to look at the market, right? Who are the parties that are settling? Are they really material in the market even together? There's that component to it as well, as I understand from antitrust lawyers. But takeaway for me is try to avoid it. And if you can't avoid it, make sure that you're doing it as narrowly as possible and understand that there is still risk associated with that.
I agree with that completely. And I think the other factor is, or another way to approach it is an agreement that says that we're not going to hire each other's employees in violation of valid non-compete agreements that we have with them, which you would hope does not include every employee in every company. And I think that's another way to address it, with the caveat that you gave, which is I'm not an antitrust lawyer either. That's just what I've seen and heard from the antitrust lawyers in addressing that issue.
Yeah, me too. And actually, I've asked that specific question and been told that that should be okay. But again, this is not legal advice.
Don't want anybody going to jail over it.
Absolutely. But I do understand, my understanding though, is that what you said is exactly correct. So that brings us over then to the non-compete side of things and what's been happening there. And people will remember, the FTC was looking at non-competes for the past several years at this point. They've held one a full day long conference and one a 2-day conference on the competitive impacts of non-competes, no-poach agreements, and other things. They also included non-disclosure agreements as part of that, and they had other topics as well. But the FTC to date, and I think what's important to take away is that to date, the FTC has not done anything other than investigate and go after non-competes in the context of M&As. And so when I say they haven't done anything, they haven't created any sort of new rules or regulations around the use of non-competes by companies with their employees. They haven't yet set a kind of schedule to do that. And given that the FTC hasn't regulated at this point, but we do expect them to, the real question becomes whether they have the authority to or not, or whether that authority is something that's vested with Congress and has not been or could not have been delegated to the FTC. And I think the prevailing view on that is that the FTC does not have that authority and has not been delegated that authority and probably couldn't be delegated that authority. But that remains to be seen. That's, something that'll come up as we move forward. They have given every indication that they're going to continue looking at this. And there was recently a submission by special interest organizations that have tried to reignite the flame under the FTC. And we'll see if that has any impact or not.
Yeah. And Russell, I know we need to move on, but just real quick, if the FTC were to issue a rule, is that the type thing? Presumably there's going to be litigation right away over whether it's valid. And with this Supreme Court, you would expect that ultimately it might get struck down. But how does that work? Would there be an injunction against enforcement of the rules so that companies could know what they need to do in the meantime? Or is that one where the rule's out there and you got to decide if you're going to take the risk of violating it versus of having it found ultimately unconstitutional?
So here's another area of law that I am not a specialist in, which is agency law. But I do believe that the rule is out there. And unless you challenge it specifically because of something you're engaged in that would violate it, I don't think that there's much that somebody can do to just, bring a challenge.
My recollection under the APA, the Administrative Procedures Act, you obviously have to exhaust any administrative remedies you have before you go the declaratory or injunctive relief route. I would presume, and again, this is what I'm wading into waters that I'm not normally wading or swimming in, but I would presume that there would be some comment period that for interested stakeholders to provide their input on any rule that was issued. But I don't know. I don't know if the FTC operates under those strictures or if it's unmoored from any kind of restraint. It seems to think it isn't bound by any restrictions, no pun intended. But I wonder whether that might be an issue that needs to be addressed.
So I don't know, but what I can tell you is just kind of going back to the beginning of all of this. There's the Supreme Court case was West Virginia versus Environmental Protection Agency,
Right.
and in that case, it was obviously a state, that pursued this. So I can't imagine another state is going to take issue with the rule, any rule or regulation that the FTC may promulgate. So I agree with you. I think there's going to be a process to follow the Administrative Procedures Act and ultimately make its way up to the courts.
It would seem to me that Eric Wives kind of has it nailed down. I think he wrote a post recently where he posited that the most likely approach is just to target what are perceived to be serial offenders that are unfairly wielding non-competes and draw them out with either subpoenas or administrative proceedings rather than issuing a general rule and taking on a larger group of adversaries that might be able to do a full frontal assault on a rule. That would seem to me to be a more effective stealth strategy by the FTC. And I think we've heard that through the grapevine that there are people that have been the subject of inquiries that are fairly broad and comprehensive from the FTC.
We have heard that, yeah, but I haven't seen any enforcement action by them, or at least nothing public. So I think it's also a very good point. I think Eric had written an article, and I'm not sure if this is the one you were talking about, if that was a different one, but Eric had written an article with Stuart Gerson where they talked about the EPA case, the West Virginia versus EPA, and they applied it to the FTC and this very process and concluded that the FTC would not have authority for this. So that then brings us over to just big picture what's happening at the state and feds, that is state legislators and in Congress with regard to federal or state legislation. And so this year I think there were 8 different laws in 3 different states, 5 different states. So you had the significant ones though were Colorado, which you may remember back in 2017, they had made a violation of their non-compete statute a misdemeanor. Supposedly nobody was prosecuted under that, but effective in March of this year, March of 22, they passed some sentencing reform, and that moved where in the statutes the reference to this being a criminal violation was referenced. And that caught the media attention, right? Because what happens at that point is people are very worried all of a sudden, not realizing that this thing was in place since 2017, but they were pretty worried at that point that, okay, now we've got criminal liability for this. That lasted only a few months because effective in August, they completely overhauled their law. And they, on the criminal side, they basically made it very clear that it's only if you use, I think it's like threats and intimidation to force somebody to sign a non-compete or to enforce the non-compete. Only in that context are you going to wind up with any sort of potential criminal liability. Otherwise, the key pieces are, there's now a wage threshold that applies to non-competes. And it started out at $101,250,000. Effective January 1, that's going up by 11.1% to $112,500. They have a bunch of other things that change in their laws. That's a significant one, but there's really a lot. And the person has to be earning that amount of money both at the beginning of their employment and at the time of enforcement. So that's a really critical piece. But you really do need to look at Colorado law. There's a lot of nuances, a lot of developments to it. Illinois passed a new law this year. They set wage thresholds, $75,000 for the use of a non-compete, and I think $45,000 for the use of non-solicitation agreements. They also passed some law about putting restrictions on the use of non-competes for nurses. And then Washington, D.C. passed a new law. Originally, you may remember they were going to do a ban of all non-competes for everybody except a few categories. Those categories where, volunteers couldn't have a non-compete. Okay, that makes sense. Lay members in a religious organization, medical specialists who earn $250,000 or more. That's basically doctors. And then they had, government employees. Those people could have non-competes. And my favorite, the casual babysitters who could not be bound by non-competes. So that was what it was supposed to be as of October 1. And then they had gotten a ton of pushback. And they changed that, and now it's just a flat $150,000 wage threshold. So if you earn less than that, which most people in D.C. do, if you earn less than that, you don't have a non-compete. Anybody above that can have a non-compete, and casual babysitters can still have a non-compete. And the threshold
my partners with younger kids are going to be very happy about that. Say, fierce competition for babysitters.
And then the medical specialist, still $250,000. And the other kind of really significant change in that law was that they originally were going to ban anti-moonlighting provisions. So somebody working for a company could go ahead across the street in the evening and work for a direct competitor. That's gone. That's out of there. There are some restrictions on the use of anti-moonlighting provisions, but it's basically gone. The other states, there was Iowa and Kentucky. They had some healthcare related restrictions they put in place, but that's really it. That's on the development on the state side. And on the federal side, there were still 6 bills, I think, coming into this year. Another bill was proposed, which was just a repeat of one of the existing 6 bills. So the bills basically were to either completely ban non-competes at the federal level, which would be the first time that non-competes have been legislated at the federal level, or it was to narrow the scope of non-competes to people who are not exempt under the Fair Labor Standards Act. So anybody who was not exempt could not have a non-compete. And then there were some miscellaneous things. If you let somebody go because of their refusal to comply with your COVID requirements, then you couldn't enforce a non-compete against them. That was one of my favorite ones. But in any event, those bills, it's the end of the legislative session. So we're going to have a new Congress in January, and after that, we'll see what winds up happening. So that's it. That's kind of the update on the legislative side. Oh, I should mention one other thing. There were a whole bunch of bills pending this year. There were actually about, I think, 98 state bills pending this year. Among them were 4 states that were looking at the Uniform Law Commission's proposed Uniform Restrictive Employment Agreement Act. It failed in all 4 states: Oklahoma, Vermont, West Virginia, and Colorado. And Colorado instead passed this other law. So we'll see what winds up happening. I expect we'll see a lot more efforts around the country to pass the Uniform Restrictive Employment Agreements Act. We should probably do an episode on that proposed legislation because it's got its pros and it's got its cons. And I think there's a lot to discuss there.
Absolutely. Well, thanks, Russell. That was really helpful, especially for those of us who have clients that have employees in multiple states around the country. It's always important to keep up with that. So, John, you want to talk to us about what's been going on in the trade secret world? It's been a busy year.
It has been. And there's been an awful lot in terms of very interesting opinions, both procedurally and substantively in the trade secret area. The thing that really jumps out at me, we've talked a little bit about this either at the start of this call before we got on, were the number of really large verdicts we're starting to see, and the potential for what may be sort of a subtle, if not significant, trend in the way trade secret cases are being tried. This fall alone, there were three very substantial verdicts that were issued in cases throughout the country. Well, really not in the fall, but beginning in the spring. In May, Appian persuaded a Fairfax County jury in Virginia to award it $2 billion. And I feel like I should lift my pinky up to my lip when I say that, like Dr. Evil, but it's hard to believe. But literally, a $2 billion verdict was rendered in the spring against a competitor called Pegasystems. The facts, like many trade secret cases, are somewhat egregious. Looks like there was a quote unquote spy that was hired, someone who had worked for a contractor that was in turn very familiar with the business of Appian. And there were some admissions by officers in depositions that were used against them in terms of whether these things should have been done or not done. But again, a very substantial verdict in front of a jury. This fall, we had two fairly sizable verdicts, one here in Ohio. Goodyear was hit by an Akron jury for about $65 million by a vendor called Coda. The case has been pending for a while. There have been a number of noteworthy opinions that have been issued on different procedural issues, but $65 million, very significant verdict here in Ohio. And then most recently, Ford was hit in Detroit with a $105 million verdict by a vendor, software vendor called Versata, for software that was being designed and had been the subject of a license agreement about 9 to 10 years before. And it was alleged that Ford misappropriated that software under that license agreement, began developing a software that was designed to help it with the management of its assembly line. So I think these cases are really interesting because they're not the only ones. As we're all aware, there have been a number of really significant verdicts over the course of the last few years. The Motorola versus Hytera case, the Trizetto case in New York, the Epic Systems and Tata Consultancy case in Wisconsin, all really significant verdicts. And as you guys know, I love to see if there are trends that are developing in our field. And 10, 15 years ago, most of us were dealing with injunctions. We were dealing with cases where we were focused on employees as the potential defendants and trying to prevent them from taking or using or misappropriating or sharing information. And you generally brought the dispute to a end pretty quickly with a temporary restraining order or preliminary injunction against the employee and sometimes their new employer. It appears that a number of trade secret owners are taking a different tact and starting to look at pursuing damages claims rather than an injunction claim in these cases. I think the Ford case and the Goodyear case are both interesting because they involve vendors. They don't involve former employees. They involve large companies that have been found to have taken software or other types of products or other intellectual property. They've been victimized by their very large customers. So some really interesting dynamics and perhaps a real change in the way these cases are tried. But the long and the short of it is, I think this is a really interesting development. Ben, I suspect that you and I and Russell, if we were to be asked how many preliminary injunctions or temporary restraining orders or permanent injunction hearings or bench trials, we rattle off a significant number. But if you were to ask us how many jury trials have we done, well, we may have done some jury trials in other contexts, but that has not been the more favored approach for trade secret disputes. And that may be changing. So I think that's a really significant development because it's going to lead to a completely different group of defendants that are being targeted because you want the deep pocket at the end of the day. You're not going to spend an awful lot of time pursuing an employee, but you're willing to spend that on a competitor or a customer that's misappropriated something that's valuable.
Yeah, I think that's right. And it seems like since the DTSA was passed, there has been an increase. Is that just my perception or is there sort of evidence to support that?
It's a good question. I'm looking at it now because I'm doing a blog post on this, having spoken on this issue at the Trade Secret Summit a couple weeks ago. And I'm trying to see if there is any kind of trajectory or empirical research for that. I do think that the enactment of the DTSA has led to more of these verdicts because when you do look at the cases, most of them are in federal court. and
Right.
DTSA claims that are being used. And my pet theory is there are a lot of displaced patent lawyers that are very comfortable in federal court, very comfortable with proceeding under a damages theory, whether Georgia Pacific or otherwise, in terms of theories of damages. And they may have been displaced by changes in patent law due to the reduction in available subject matter due to Alice and the Mayo decisions, or by virtue of the fact that more patent disputes are pending before the PTAB rather than in federal court. So you've got a lot of very capable lawyers that can manage a trade secret case and understand that intellectual property regime and are very comfortable using the DTSA to pursue claims similar to the claims they would pursue in a patent case. Just a theory of mine. I don't know whether it bears out, but I think the DTSA is that vehicle that's made that much easier for those lawyers to find employment.
Yeah. And you may be right. It'll be interesting to see how that continues to play out. It certainly seems like there's more verdicts and much larger verdicts than we've ever seen before.
I mean, 10 years ago, it was the DuPont versus Colin case and the France case with Mattel and MGA. And those were really the only two big cases. And it was perceived as they were perceived as outliers. And now they're no longer outliers. Again, this year alone, you've got those three significant verdicts. And if you look at 2020, 2021, you'll see a similar number of big verdicts.
All right. Well, Russell, any other thoughts or comments on the trade secret developments? I know you missed a little bit of John's update there.
Yeah, I fell off, but I am back, and hopefully everything was recorded seamlessly through that. I guess no. I heard you talking about the big verdicts, and obviously there have been a lot of cases, and obviously Appian being the biggest one. But no, I will defer at this point.
Looks like there's some interesting issues in that Appian case that are going to go up on appeal. It'll be fun to watch and keep an eye on what happens there. Damages issues and software trade secret issues. So it'll be fun to watch.
I agree. Well, another development that I think is noteworthy for this year is increasingly an emphasis on Twombly, Iqbal, and other doctrines or arguments that are being advanced at the motion to dismiss stage. And I know there's an opinion that Russell and I've talked about recently that came out of the Second Circuit, Turt Labs, that found that case was ripe for dismissal because the plaintiff in that case was unable to really articulate the existence of a written agreement that was in place. And essentially, the Second Circuit found the absence of that written agreement was fatal to the trade secret claim. And you're seeing more and more motions to dismiss. I'll get back on my soapbox as I've complained before. I think there are too many of those, but that has been a natural consequence of being in federal court under the Defend Trade Secrets Act, as you are going to be open more likely to a 12b6 motion than you would be in a state court proceeding, which had been maybe the favored forum before the enactment of the DTSA. So I don't know if either of you have been the beneficiary of a ruling like that, or have been on the wrong side of ruling for a motion to dismiss. But I do think that's a noteworthy development as the DTSA continues to evolve and be interpreted by courts.
I have been involved in motions to dismiss involving trade secret claims, but neither the beneficiary nor the victim of this particular issue, I'm happy to say.
Yeah, that's good.
Yeah, me neither. And I know at our trade secret summit at AIPLA, there was some disagreement in the room. Mike Weil was, an advocate for filing a motion to dismiss in just about every case. I think the majority of us felt that was maybe not the best strategy, and that, seeking identification with specificity was a more potentially more fruitful endeavor. So it just depends, I think, court to court and state to state. But I find it's very difficult to get a trade secret claim dismissed at the pleading stage unless the other side just doesn't know what they're doing and doesn't plead it properly.
I agree.
I would agree as well.
Though I will say that Turt Labs case, that was a wake up call for some people, at least in it was the Sixth Circuit, I think.
Second.
That was the Second Circuit. Yeah.
Yep.
Okay. Yeah. Oh, right. It was the Cod Hill case. That was the other one that was a big case this year. That was in the Sixth Circuit.
Yeah.
Well, fellas, I think that was a really good year in review. Hopefully our listeners will enjoy it and get some information out of it. And we'll have to start planning our episodes for 2023. It's hard to believe we're talking about that already.
That is crazy. Well, happy holidays, everybody.
Yeah, absolutely.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.